Today, verdicts were announced in the Ahmaud Arbery case where 3 white men were convicted of different degrees of homicide for the killing of Ahmaud Arbery. As many of you are probably aware, the situation was something along these lines, and I haven't followed the case that closely, not as closely as I did the Rittenhouse case, so my facts may be off a little bit, but 3 men, 2 men in one vehicle, another man in a second vehicle, drove down the street. Ahmaud Arbery was jogging along the street. They stopped him. They tried to execute a citizen's arrest on him, or at least that is what they claim. And during the interaction, one of the men, Travis McMichaels, shot and killed Ahmaud Arbery. Now, the verdict came in today convicting all 3 men of various degrees of murder, and that's a huge step in the process. But in my opinion, there is a huge issue that was decided by the trial judge earlier in the trial that will really affect how this case goes on appeal. I think this single issue could lead these verdicts of guilty to be overturned and possibly grant the defendants in this case a new trial. Hello everybody, my name is Joe, the lawyer, Joe Pometto. If you like my content, please like, subscribe, comment, and share. I'm really looking to get monetized on this channel, so all those things will help me. Subscribe to the channel. Go ahead, give me a like. It helps me get a higher ranking in the YouTube algorithm. So let me start out by saying I do believe the actions of these 2 men, when you watch the video and you hear some of the facts, were abhorrent. They were terrible actions. Mr. Arbery's jogging down the street. These guys drive up in 2 cars with guns and try to enact a citizen's arrest. Okay, I think that they were abhorrent. This was an abhorrent act by these men. However, under the law at the time, there could be a big issue here for appeal, even though these men were convicted and found guilty. So you can see here on this article, defense says ruling by judge in Ahmaud Arbery trial over citizen's arrest law guts their case. I agree with that defense attorney, and this article will give us a little bit of context. What was expected to be a relatively calm day in the trial for the shooting death of Ahmaud Arbery ended in fireworks once again, and this was on November 19th. Deliberations started, I believe, on the 21st. I can't remember exactly when the trial ended, but the verdict came back on the 24th. So this was before the jury had went out. The trial was still ongoing. The judge ruled Friday afternoon that under Georgia's old citizen's arrest law, the one applied in this case, the arrest would have to occur right after any felony crime was committed, not days or months later. The defense argued that the ruling guts their case. If you are going to instruct the jury as you say, you are directing a verdict for the state, said Bob Rubin, attorney for Travis McMichael. We have built this case around the probable cause, and you are gutting all of it if you give this particular charge, Rubin said. Greg and Travis McMichael, along with Roddy Bryan, say they were trying to make a citizen's arrest of Arbery, believing he had previously committed crimes in their neighborhood, but they had not witnessed any crimes themselves or knew of any immediately before they began chasing him last year. So the issue here is the timing. The timing. What timing does the law require? Travis McMichael shot Arbery in what he claims was self-defense during a struggle. I understand the significance of this charge. Now, there were some other things mentioned here in the article, but let's jump to the citizen's arrest law that was in effect at the time. The Georgia legislature, 15 months after the incident occurred, changed the law. So that new law does not apply. Let's read this law word for word. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. So there's multiple elements to this. One of the elements is the requirement of a felony in order for the citizen to stop the person from escaping or attempting to escape. And burglary, which is what the McMichaels claim they believed Arbery had committed, would qualify as the burglary. So then as a felony. So that would allow the statute to be applied. However, then a private person may arrest an offender if the offense is committed in his presence or within immediate knowledge. That's an or statement there. So they don't need both, they need one. Obviously, from all the facts that I've heard and read and from the trial, they did not view Mr. Arbery committing a felony in their presence. Thus, it would have to fall to immediate knowledge part, the immediate knowledge part of the statute. And what the judge stated essentially, and I watched some of the arguments, was that he did not believe that this law should be applicable in this case because what the McMichaels stated did not qualify as a felony within their immediate knowledge. So they stated that they had knowledge that burglaries had been committed within the past days or within the past weeks, and that those burglaries, and that they had reasonable cause to believe that those burglaries were committed by Mr. Arbery, I believe because he had been spotted in the area previously. So that's pretty tentative, right? Like you're driving down the street, you see this guy, you knew he was in the area within the last couple of days when burglaries had also been committed. Can you enact a citizen's arrest on him? Is that immediate knowledge? Essentially, the judge said no. The knowledge of the crime had to be immediate, okay? And so for something that allegedly occurred days or weeks or in the months past, it did not apply under the judge's reading of the law. Therefore, the judge gave an instruction telling the jury that. And because he told the jury that whenever they were going to deliberate, the jury likely did not take into account the citizen's arrest aspect of this case. And that would have a huge impact on the outcome. Now, let me connect one more dot here, because this case has been framed as self-defense on the part of McMichaels, and there is some truth to that, but it's actually twofold. It's a self-defense and a citizen's arrest case, and the McMichaels would need the benefit of both of those conclusions. They would need the jury to conclude, number one, that they were acting on a citizen's arrest, and number two, that they were acting in self-defense. And the reason for that is a little more complicated, but I'm gonna connect that dot here, because self-defense, in order to make the self-defense argument, a person cannot be seeking out the content or the interaction or be the cause of the interaction. And I explained this in a prior video. So if person A walks up and starts punching person B, and then person B starts punching to defend themselves, and then person A has to punch back afterwards, those subsequent punches from person A do not qualify as self-defense. Person A caused that incident. Let me give you another scenario. Person A is chasing person B with a gun. Okay, and then person B turns around, sees a gun pointed at him. Person A runs up to defend himself from the gun, or I'm sorry, person B, remember A has the gun, B sees a gun being pointed at him. So B runs up, starts a struggle with person A, and then person A, boom, shoots person B. Person A may have lost the right to self-defense because they initiated the contact and they were the initial aggressor. It's a special theory in self-defense law. Well, here in the Arbery situation, these three men, when they confronted Arbery, they were the initial aggressors. They were the initial aggressors. And then Arbery, this guy's got a gun. He's pointing it at him. Arbery grabs him. I don't know if he grabbed the gun. I don't remember all the facts. But a struggle ensues, and McMichaels shoots Arbery. And Arbery dies. Okay. So McMichaels here would be easily viewed as the aggressor because Arbery's jogging along and these guys, drive up on him. However, they could get out of that aggressor situation if they can get the benefit of this citizen's arrest statute. If they can get the benefit of this citizen's arrest statute, because if they're enacting a lawful arrest, they are basically in the shoes of police officers at that point in time. And they would not be viewed as the initial aggressors under the law if they had reasonable and probable grounds of suspicion for the arrest, and they could claim the citizen's arrest. So really, what the McMichaels needed was they need number one, to show they were acting under a lawful citizen's arrest, and then number two, while enacting that lawful citizen's arrest, they acted in self-defense. They needed to prove both of those in order to get an acquittal under the law. And the judge in this case said, I'm giving an instruction that's not going to allow you to have the benefit of this Georgia code, this citizen's arrest code. Now, the judge, in doing that, I'm not claiming whether he was right or wrong in doing that. Here it says it committed in presence or within immediate knowledge. You're going to have to dive deeper into Georgia law and jurisprudence to know exactly what the court's interpretation of immediate knowledge is. Does it mean that the McMichaels just had it on their mind that a felony had been committed and he was a possible suspect? Is that immediate knowledge? Or does it mean, is it the timeline argument, okay, the proximity and time argument, or does it mean that the alleged crime in their mind had recently been committed? And the judge essentially said it does mean that the crime must have been recently committed. At least that's part of the reason he gave the instruction that he did to the jury so that they could disregard this citizen's arrest statute. This is a very interesting, you can tell from what I stated here, it's an interesting issue. It's complicated. I haven't read the case law on it, and prior Georgia jurisprudence will decide. What do I mean by jurisprudence? Well, the opinions written by other courts on this law will decide whether or not the McMichaels will be able to overturn this case on trial. But I can tell you, this is a complicated legal issue, and it's likely going, not on trial, on appeal. It's likely going to, that's going to be a large portion of what the defense attorneys argue on appeal, and I can see oral arguments taking place in the Superior Court in Georgia and perhaps even the Georgia Supreme Court. It could even go beyond that in order to interpret the true meaning of this statute. I think that gives the McMichaels an opportunity to have this verdict overturned, and it would mean a new trial for them. And then the Supreme or the Superior Court would tell the judge exactly how he needs to instruct the jury on the second trial. Because it's true. I think the defense attorneys were right in that the judge's decision on the citizen's arrest statute guts their case. And this just goes to show what you hear in the mainstream media. Well, the Rittenhouse and Arbery are both self-defense cases. Well, yeah, but Arbery was more a citizen's arrest case than a self-defense case. And the Rittenhouse case was very much a self-defense case, and none of the legal analysts that I saw touched on this very well. I'm not saying that they weren't out there. I'm just telling you that I should be on the news explaining to the public the law. Yes, I believe in myself, ladies and gentlemen, but I have a great degree of humility as well. So, just wanted you, and again, I think the actions that these men took were absolutely absurd, abhorrent, and ridiculous. If they had a suspicion like that, they could easily just call the police. And Georgia changed the law, but the prior law and the interpretation of that law may allow these men to get the case overturned on appeal. Thank you, everybody, for tuning in. I'm Joe Pometto, Joe the Lawyer. If you like my content, please like, subscribe, and share. And also, just because it gets overturned on appeal doesn't mean they won't be convicted the next time. But it would change the dynamic of the case. Thank you, everybody, for tuning in. Joe the Lawyer, signing out.